everyone, good afternoon. My name is Karina. I'm the self-service administrator here in Palm Beach County Clerk and Comptroller's office. And today's workshop is going to be about homeowner and condo owner association laws. Just to give you a little overview of what we'll be going through, I'm briefly going to tell you about the Clerk and Comptroller's office for some of my repeat attenders. Bear with me. Then we'll talk about the differences between homeowner association and condo owner association laws, because they do have two different statutes in Florida. We'll talk about the powers and the duties of associations, which is really where the intersect with the court and the legal aspect comes in. We'll talk about the home or condo owner's rights and obligations, and we'll talk briefly about the election and recall process, and then about the different services that are available in Florida for disputes such as arbitration, mediation, and if you can't resolve it there, litigation. And then we'll have a time at the end if you have any questions, if you could please save them for the end. I will try to answer as many questions as I can. I will tell you that HOA and COA law can actually be quite complex. And I'm not allowed to give anybody any legal advice as an employee of the clerks. If you do have a question that I don't know the answer to, feel free to write it in the comment section of the evaluation with your email, and I will find out for you and give you a response. We don't have that much interaction with homeowners associations and condo associations in the clerk's office until it gets to the very end where they're filing a lawsuit or a lien. So anything that's before that, if I don't know the answer, I'll make sure to investigate it for you. So here at the Clerk and Comptroller's office, we are the trustee of the county's public funds and public records, and we offer various services to the community, and one of them is our self-service centers. At our self-service centers, we have form packets for different kinds of cases that people who are representing themselves can use to help them start their case. And we have 70 packets at the moment. There's a list of all the packets there. It's one of the flyers that you have, and various costs depending on how many page numbers they are that the public can purchase to help them file for divorce or eviction, small claims, many different kinds of family law or civil actions. We also have contracted with several attorneys. They cannot give people legal advice either, but they can help with form completion and procedural information. So their services are $1 per minute in increments of 15 minutes. So if you purchase one of our packets and you want help filling it out, you can make an appointment with one of our attorneys. And we have this service at most of our locations, so in Palm Beach Gardens here in West Palm Beach, and at our Delray Courthouse as well. We also have public access computers for researching your case, an e-filing station, notary services, and more. And just to emphasize, none of the clerk employees can give you any advice about which packet that you should purchase, but we can give you your different options and explain to you some procedural information that might help you decide which is the best form for your particular situation. Okay, so we'll start with homeowners association versus condo owner associations. What's the difference? Well, I was surprised in researching the difference, which is mainly that condo owner associations are much more regulated than homeowner associations. Okay, there are two acts: the Homeowner Association Act and the Condo Owner Association Act. But the Condo Owner Association Act is more extensive, and the condo owner associations have a regulatory agency which homeowners do not. And that is the Division of Florida Condominiums, Timeshares, and Mobile Homes. And this division provides different services. They provide condo owners with mediation and arbitration for most disputes. They do provide homeowners and HOAs election and recall arbitration, but they don't provide them with assistance in any other kind of dispute that anyone may have with their homeowner. And they do not provide any kind of mediation for homeowners associations. The division also provides training, education for COAs on how to manage their properties. And the division is led by the condominium ombudsman. It's a tongue twister there for you. The condominium ombudsman gives advisory opinions to the governor, state agencies, and if requested, condo owner associations or condo owner members can seek an advisory opinion from the division. And the condominium ombudsman can also appoint election monitors. There are some rules about that that we'll talk about later in the workshop. So the main difference is that condo owners have a structure, an agency, and a representative that they can go to if they need any clarity or assistance with any disputes. And the homeowners do not have that at this time in Florida. They do have an act, which we'll talk about now. So before we talk about the powers of the associations, we'll talk about where are these associations' powers defined and derived from. So I mentioned there were two acts. The Homeowner Association Act is Florida Statute 720. The Condo Owner Association Act is Florida Statute 718. This presentation has been uploaded on our website, so not only can you read it, and the PowerPoint's already up there, and the video recording that's happening now will be up there in a few weeks. But it has a live link to the statutes and to all the contact information for the ombudsman and the division. So if you don't have to feel like you have to frantically get it all down today if you miss anything. So those are the two statutes, and I'm going to walk you through the main components of the statute today. However, what's really important is that you know the individual articles of incorporation, declaration of condominium or covenants, bylaws, and rules of your association. And I'm going to be referring to those throughout our presentation as the governing documents, because oftentimes that's what the statute calls them. Because if you read the statutes, they'll often say that that rule is a default. So it'll say, as directed in the governing documents, or if silent, and then it'll tell you a rule. So what the statute says is not always necessarily what's going to apply to your particular association. In addition, sometimes the statute will just have a minimum or a maximum, but allow the association to vary as long as they stay within that range. So that's why it's important, if you're having an issue with your homeowners association or condo owner association, that you read these documents that are particular to your association. So condo owner and homeowner associations in Florida are treated like businesses. They are required to incorporate and register with the state and have articles of incorporation and bylaws. And they also have to record the particular rules that may have been voted on by the members. You have the right, if you are a homeowner association member, to review any of these documents. They have to be made available to you. And starting in July, if you're part of a large condo owner association, 150 units or more, they must also make it available on their website. A lot of associations already have these documents on their website, but some would still require you to come to a central office if you wanted to review, inspect, and copy the documents. But the statute does say that owners have a right to review all those documents, and that's really what you need to know if an action being taken by your association is proper and allowed. So, association powers. We're going to go over some of the general powers. As I mentioned, both statutes are quite extensive, so I'm just going to try to touch on the major ones. A homeowner or condo owner association may initiate, maintain, defend, settle, or appeal any lawsuit on behalf of its members. The statute just says that it must be regarding an issue of common interest, and only if the lawsuit is for $100,000 or more must they actually have a meeting and get the vote for the majority of the members of the association. The association can assess and collect fees, dues, fines, and other assessments per their governing documents or as voted on by the members. And they can require that you submit any plans for improvements or building on the property to them for inspection before you're allowed to proceed with that. The association also has the right to fine you if you fail to comply with any of the provisions in the governing documents that we talked about. And there's different ways that they can do that. They can institute a monetary fine. There are some limitations in the statute. So the statute says that the fine cannot exceed $100 per day of violation or $1,000 total per violation, unless all the members have voted that they're going to have a higher amount, and that is in the governing documents. That's a little tricky though, because with one notice, they can continue to fine you for every day that you're in violation. And so, for example, I'm not saying they would fine you for this, but just for example, if you're getting fined for leaving your trash cans out on the curb and you do that for 5 days, they can charge you that $125, and then you bring them in and the following week you do it again, then they could fine you again. So although it says $1,000 total per violation, if you violate the same provision but on a different occasion, then they can exceed that $1,000. Okay. They can also suspend the right of a member or of a member's guests and tenants to use the common areas or facilities for failure to comply with the rules, or if you are more than 90 days delinquent on your dues or fees. If you're delinquent, they can also suspend your voting rights. And the statute says that if they're going to deny you access to the common areas or facilities or charge you a fine regarding a violation of the rules, they have to give you both notice and an opportunity to have a hearing if you would request it. The hearing is not a judicial hearing, it is a hearing in a panel. It says they have to choose a panel of 3 members that are not part of the board of directors, and you do have that right to that hearing. But if you are being suspended or being denied use or fined for being delinquent on your fees, they are only required by statute to give you notice of what your delinquency is, and that you will be suspended until those fines and fees are paid in full. They are not required to give you a hearing on the fees, which, if you're in a condo owners association, you could contact the division to request some sort of mediation or arbitration. But if you're in a homeowners association, you would have to try to negotiate with them, or ultimately file some sort of action if they take it further and try to enforce it, which we'll talk about in just one second. So, another one of the association powers, and as I mentioned at the beginning, this is where it kind of intersects with the court and what we do here. If you are more than 90 days delinquent and you owe more than $1,000 to your HOA, then they can obtain and record a lien on your property. Okay? And they can get that lien not just for the amount of dues or fines that you owe them, but the statute allows them to add several things to it. They can add late fees, which the statute does says can be no greater than $25 or 5% of each late installment. But just like as I mentioned with the violations, that can accumulate. So if you're supposed to pay this monthly, every month that you're not paid in full, they could assess that late fee again. Reasonable attorney fees and costs, and what's reasonable for a private attorney, can be thousands of dollars. And interest, which it says per bylaw are 18%. So the statute doesn't say that it has to be 18%, but it is establishing that as what the legislator believes is reasonable, which is quite high, 18%.
Excuse me?
Yes, sir.
I served a lien notice on a $25 late payment. And then someone had contrived some false delinquency, and I was in a great state trying to resolve this, but the total sum with the attorneys costs came to over $1,000. So
correct.
Are we talking about the total figure being in excess of $1,000?
The total figure, including all these things, correct. So it's oftentimes the lien could be for a dues that was only $250, but when they add the late fees and the attorney's fees and interest, then it exceeds the $1,000. So that is correct, sir.
So controlled.
In order to be able to obtain a lien, the association must first make a formal written demand for the amount due, and it must notify you that they intend to file a lien. The statute actually has a sample form, if you're part of the board of an association. The statute has a template that they can use for that notice. And they have to give it to you at least 45 days before they intend to obtain the lien. If you're in a homeowners association, and I'm not sure why, but it's a different number for condos, it's at least 30 days notice that they have to give you. It's a little bit different. Whenever there's a distinction between the condo and the homeowners association, I'll point it out for you throughout the presentation. In addition, the statutes say that these liens have priority over most creditors. Sometimes they call them super liens. Really, other than the first mortgage on the home, for anything after 1992 for condo owner associations, and I believe 2008 for homeowners associations, when they record a lien, the date of priority goes all the way back to the filing of the governing documents of that association, not to the finding of that lien, which means other than your bank that you owe the mortgage to, they have priority over any other creditors that might have a lien over your property. So, if you're a homeowner and you disagree with the lien, you can file and record a notice of contest of lien. And there's also a template in the statute that you can use. However, when you do that, instead of just negotiating with the association, they then have 90 days to file an action to enforce the lien, or the lien becomes void. So if you're doing that, you just realize that if they believe that it is correct, there's somewhat of a motivation to now file a suit for foreclosure or some other kind of enforcement action against you, because otherwise that lien is no longer going to be valid. So they have 90 days to file some sort of action to enforce the lien, and one of the ways that they can enforce the lien is to initiate foreclosure proceedings. And a lot of people don't know that an HOA or a COA can foreclose on your home even if you're current on your mortgage payments. So they can foreclose on your home just for that $1,500 lien that they have on your home. Okay. If they choose to file a foreclosure action, they must give you another written notice with the same timeline, 45 days before for a homeowner and 30 days before for a condo owner, and that they intend to initiate the foreclosure if you do not pay it in full within that time period. Okay. Once they've filed the foreclosure action, the statute says it proceeds the same as any other foreclosure action that a bank would do for a mortgage. Follows the same foreclosure rules, and it references you to that statute. While the case is pending, if a homeowner perhaps can come up with the money, but just needs some time, you can file what's called a qualifying offer. There is a template for the qualifying offer in the statutes, both statutes. And this will stay the proceeding for 60 days. Well, actually, it could be less than 60 days if you specify that you need less time, but it cannot exceed 60 days. You're only allowed one chance to do this during the foreclosure proceeding. So if you say, I need 60 days and I can pay this amount in full, and then you're unable to do so, the foreclosure action will continue to proceed. And if you get the money 2 weeks later, you can still propose it to the association, but you won't be able to file another one of these qualifying offers with the court and get that automatic stay. The statute specifies that you're only allowed one per action. Okay, you have to do that before there's a final judgment of foreclosure entered in your case. If the foreclosure is finalized, the law clearly states that you're still liable to the mortgage company if you still have a mortgage on that home. And how this plays out is different in every case. In some cases, the bank joins the foreclosure action of the HOA, or sometimes, there's a notice of sale that the house is sold, then the bank gets paid off and the HOA gets paid off. So it kind of plays out differently in every case depending on how the bank chooses to proceed. Sometimes the HOA buys the property. Yes?
Even if the property manager has made a mistake in enforcing this, you still got to go through this whole procedure, don't you?
Well, if they don't believe they've made a mistake and you can't work it out with them, is it for a home or for a condominium, sir?
Yeah, but when you're under a lien notice,
Right.
you've got to work very quickly, especially in Christmas
That is correct.
time in my case.
Yes, it is very quick. Yes. So is it a home or a condo? It's a condo? Well, you do.
It's resolved now.
Oh, okay. Well, like, if we can save the questions for the end, that way we can get through all the material, and then I do have a question and answer period at the end that you can ask any
sorry.
questions. No, no worries. Yeah. So, okay. So just a few other miscellaneous powers that association has. They can enter into contracts with service providers. So some homeowners or condo owner associations, they provide cable or internet to the community. The statute actually says, however, that any contract entered into by an association can actually be canceled if the majority of the members would like it to be. But that majority vote has to happen at the next regular or special meeting that happens after that contract is entered into. And if at the very first meeting after the contract is entered into, no one brings it up or it doesn't pass the vote, then the contract remains in effect until the end of the term of whatever that contract is. Okay. And finally, the statute gives associations some emergency powers. So if a state of emergency is declared for a hurricane or something of that nature, they have some additional powers that vary from what their governing documents and the statute says. So, for example, they can call necessary meetings without the required notice that the statute requires. They can enter into contracts for debris removal or other things related to safety that they would normally need a vote for. And they can appoint temporary officers if the officers or board of director members are unavailable because of the emergency. So, what are the association's duties? They are responsible for maintaining, managing, and operating the property. For HOAs, the statute says they're responsible for common areas, whereas for condominiums, it says condominium property. They do have more leeway in the management of condominiums because of the shared, the shared walls and the shared other components of the structure. So if you read the COA statute, you'll see it goes into more detail about their ability to enter your property to be able to repair it, whereas the homeowners association statute doesn't go in that since they're only responsible for common areas. The association must also provide financial documents to its members. It must create an annual financial report for the preceding fiscal year and also a budget for the upcoming year that includes any estimated revenues and expenses, and they either have to send those documents to the members or send them a notice that it's available to them should they like to see it. They must conduct board meetings and they must notify the members of the board meetings. The governing documents can specify a specific time. If they do not, the statute says it has to be at least 48 hours in advance. The notices for a board meeting are not as extensive as for an annual meeting, so posting it in a conspicuous space would be sufficient notice for the board meeting. They must hold an annual meeting for all of the members, and at that meeting, they must give notice at least 14 days in advance, and it must be either by mail, hand delivery, or electronic transmission. But if it's electronic, they need the consent of the members that they agree to receive notice that way. And they must also post it in a conspicuous space, so that little sign when you walk into your neighborhood. At the annual meeting is when any election of directors must take place. And in addition to the annual meeting, if at least 10% of all the members in an association want to have a special meeting and request it, they are required to hold a special meeting as well in addition to that annual meeting. Whenever you're going to vote at a meeting for association, you need a quorum, and a quorum is different for a condo or a homeowners association. So a quorum just means how many people need to be present at the meeting before they can even have a vote. And for homeowners associations, only 30% of the voting members, whereas for a condo, you need a simple majority, which is 50% plus one. Okay. In addition to holding meetings, associations are required to maintain official records relating to their association. And for most of the documents, the statute specifies that they must retain these documents for 7 years and make them available to homeowners for inspection, copying. That includes the governing documents that we talked about, minutes of all meetings, a roster of all members, any insurance policies that they've held in the last 7 years, financial reports and accounting records, and any plans or permits for any kind of improvement or building that has occurred in the community through the HOA. Okay. So now that we've talked about the powers and the duties of associations, we're going to talk a little bit about member rights and responsibilities. It will somewhat mirror what we talked about, but there are some additional provisions in the statute. So you have the right to attend any board meeting, and you have the right to speak at any board meeting or member meeting. And the statute even says you have the right to record any meeting. But it does allow the associations to put reasonable time, place, and manner restrictions on that speaking and recording. So they can say, for example, that each member is allowed to speak for a maximum of 3 minutes, and then at the end of the meeting, if there's additional time, they can speak further. So they are allowed to put restrictions on how long you can speak or how often you can speak on the same issue. The statute also says that owners have the right to get things on the agenda for the meeting. So if at least 20% of all the voting members petition for the board to address an item of business, they must address it at the next meeting or at a special meeting, but no later than 60 days after receiving the petition. So you can ask that something be addressed that wasn't maybe on the agenda that they initially stated. And as I mentioned earlier, you have the right to inspect and copy most association records. There are some limited exceptions. For example, anything that is work product of the association's attorney that may have confidential communications between the association's attorney and the association board members. Anything that has to do with electronic security measures the association has, or any portions of documents that may contain social security numbers, driver's license, or medical records of any of the homeowners or the board members. Okay. Continuing with the members' rights, members also have the right to peacefully assemble in common areas and facilities, including the right to invite guests, including the right to invite candidates for office or public officers. And it gives you the right to be protected against retaliatory lawsuits. So it specifies that if you feel that a lawsuit was brought against you by the homeowners association because you wrote to the ombudsman, or you asked for certain repairs, or contacted a state agency regarding something going on with the association, and you can present that case to the court, you can be awarded damages, attorney's fees, and costs for defending yourself and seeking a motion to dismiss that lawsuit. And finally, members also have a right to vote in board member elections, vote on amendments, or on any common expenses that the board is seeking to add. Unless, as we discussed earlier, you've been legally suspended for not paying those fines. And then you can be prevented from voting on any issue until the fines are current. Okay. If you're a member of a homeowner association, you have the right to run for the board of directors. There are very limited exceptions. One of those is if you're delinquent on the fees. So the trend that we see through this workshop is if you're delinquent on the fees, pretty much all of the rights that are provided by the statute are suspended until you catch up with your payments. Or you're a convicted felon. And even convicted felon, if your rights have been reinstated for at least 5 years and it's not a crime of embezzlement or certain kinds of theft, you would still be allowed to run for the board of directors of a homeowners association. And there's an additional right that is in the condo owner statute. Remember I said there's some differences between the condo owners and the homeowners. The Condo Owner Association Act gives you a right to a response to written inquiries. What that means is if a unit owner files a written inquiry to the association, they have to respond in writing within 30 days. During that 30-day period, they can either give you a substantive answer to your question, or they can tell you that they require legal advice and they're consulting with an attorney, or they can tell you that they have written the division of condominiums and they are seeking an advisory opinion from them before they respond to you. And then they must follow up when they receive either the legal advice or the response from the division. This particular right is not listed in the Homeowners Association statute. Okay, and then these are the final rights that we're going to discuss. They're the really random miscellaneous ones. You have the right to display a portable, removable U.S. flag, a state flag, and one flag from one of the branches of the U.S. military. But the statutes vary on how big they can be. Obviously, the size restrictions are smaller for condo owner associations. You can't be prohibited from implementing Florida-friendly landscaping. And if you don't know what that is, there is a specific statute that defines it, that it references you to, which is Florida Statute 373.185. I see someone has this issue. 185, yes. You have the right to construct a handicap accessibility ramp for medical necessity or disability, but the statute does say that you would have to provide proof of that medical necessity or disability to the association. And finally, it says if the association has a contract for any kind of cable or internet services, you can't be denied using another provider as long as you pay for it directly. However, that doesn't get you out of the whatever assessment the association is charging you for the contract that they've entered into, so you would essentially be paying for more. The statute has some exceptions for people who are hearing impaired or legally blind, that they would be able to not have to pay the assessment if they could provide documentation. Okay. The statute doesn't talk too much about member obligations. It mostly defines the powers and the obligations of the associations and the rights of the members. But it does generally say that members, their tenants, guests, and invitees, as well as the HOA board members, are required to comply with both statutes, the governing documents that we discussed, and all the rules of the association. And failure to do so can be addressed, as we discussed at the beginning of the presentation, with suspension of rights to use common facilities, with fines, with litigation if the fines reach a certain amount and they obtain a lien or attempt a foreclosure action. And you must timely pay any legally assessed dues, fees, or assessments, which can be penalized the same way with the suspension, fines, or litigation. What a lot of people don't know is that the statute says you're also jointly and severably liable for any, if you buy a home, for any HOA dues or fines that were owned by the previous owner. And what that means is that they can choose to go after you for that past due amount as the new homeowner, even if it was owed from the previous homeowner. They can choose to go after the entire amount from you. Now the statute just says then you can seek reimbursement. You can file an action against the previous homeowner to be reimbursed, but you are 100% liable in the eyes of the association according to the statute. Yes. Okay, so we've talked about all the association's powers and duties and the members' powers and duties, and I'm just briefly going to talk about, actually a large portion of the statute is about elections and recalls, but I'm just going to briefly touch on it. As I mentioned earlier, the election of board members must happen at that annual meeting unless there's some emergency vacancy, mid-year. And you need that quorum to be present to have an election. Both statutes require a secret ballot, but if you are a member of a condo owner association, they do not allow for proxy voting, whereas in homeowners associations, you can vote by proxy. The condo owner association statute goes into much more depth about elections because they have this regulatory agency that one of its primary goals is to make sure that there is not some sort of election fraud in the condo owner associations. And only for condo owner associations, I mentioned earlier that the ombudsman can appoint an election monitor. And in order to do that, at least 15% of the total voting members, or if it's a small building, at least 6 members, whichever is greater, would have to petition the ombudsman and ask him to appoint an election monitor. There is a nominal fee that the association members would have to pay for that. If you wanted to dispute an election, The Division of Condominiums and Timeshares actually handles disputes for both HOAs and COAs, and you'd have to file a petition with them at least 60 days after the election results are announced. You have to give the association notice first that you intend to do that, and time to try to remedy whatever the objection that you have to the election is. If they do not, then you would choose a member representative and file that petition with the Division of Condominiums. They only charge condominiums $50 for that petition, but it's $200 for homeowner association. That is just the initial filing fee. Then you're going to have to submit to mandatory arbitration. And at the end, whoever the non-prevailing party is will be billed for whatever actual expenses were incurred by the arbitrator. So copies made, any travel. The statute does not specify the amount. It just says amount adequate to cover all costs and expenses incurred.
So petition carefully.
Correct. The division also handles recalls of board members. Both in a homeowner association and a condo owner association, members can recall a board member at any time with or without cause, as long as they have a majority written vote or written agreement. Okay? You have to present the written vote or written agreement of the majority of the members to the association by certified mail or personal service, and then they have 5 business days to hold a meeting about the recall. If they don't do so, then the board member is automatically recalled. If they do so but choose not to recall the member, then you or the association or the board member could file a petition with the Division of Condominiums to request arbitration again. Before you could file any kind of lawsuit, you would have to go through the mandatory arbitration process. And the costs are the same as for election disputes, $50 for condominiums and $200 for homeowners associations. So, I mentioned this election dispute and recall arbitration and mediation. If you are a member of a condominium association, the division provides free or paid, they have an income scale, mediation if you would like to participate in mediation prior to arbitration. Because even though arbitration isn't filing a lawsuit in court, what the statute states is if you don't file a lawsuit to contest an arbitration decision within 30 days, it does become binding. Okay, so then it is a final order. So some people would prefer to mediate it, and if you're part of a condominium association, you can request that through the division to have mediation before you even begin the arbitration. But if you are a member of a homeowners association, you would have to seek private mediation, because the condominium association division is not allowed to provide that for the homeowners. And the division will also provide condominium members mediation and arbitration on any other kind of dispute having nothing to do with elections, even payment of fines, as long as it's incorporated somehow in the statute. It has to be a provision of the statute that one party or the association is claiming is being violated. So it's the services they offer condo owners are more extensive. Okay. If the matters cannot be resolved in arbitration or mediation and a lawsuit is filed either by the association or the parties, almost every provision in the statute states that the prevailing party in a lawsuit would get attorney's fees and costs. So something to keep in mind. In some cases, it even says that willful violation would allow for damages. So when I talked about the retaliatory lawsuit, if you can prove that and you are successful in defending a retaliatory lawsuit, it does allow for damages to be paid to the prevailing party. In all the foreclosure actions that we talked about, the prevailing party will get attorney's fees and costs. I mean, it's already added into the lien to begin with. So. Okay, I have some helpful links, and as I mentioned, this presentation is online, so you could, they're active there, and then we'll open it up for any additional questions anyone may have. So I've talked at great length about the Division of Condominium, Timeshares, and Mobile Homes. That's their website there. You can find the forms to request mediation or arbitration on that link. The Condominium Ombudsman has his own page. That's the link. That is the email if you'd like to make an inquiry of the Ombudsman, and the phone number. And if you want to read those statutes, because as I mentioned, I provided you an overview, but they do go into great detail. You can go online and read the statute. The Homeowners Act is Florida Statute 720, and then we have the Condominium Act 718. You can always go on mypalmbeachclerk.com, not only to see this presentation, but any of the presentations that we do. We have these workshops here in West Palm Beach the first Wednesday of the month, the fourth Wednesday of the month at our branch locations, and the topics vary. So if you're not already on the mailing list, you can ask to be added to the mailing list, and I send out a monthly email, or you can go on our website and see the different topics. We do everything from divorce, eviction, etc. So does anybody have any additional questions? Yes, ma'am.
I don't know if it's anything that you could even answer or get into, but I live in a very small townhouse development in Wellington.
Okay.
Anyway.
Yes.
And the issue that we have going on right now, and it's been going on for about 4 years now, is the president is doing proxy hoarding. There's a lot of apathy in the community.
Yes.
And he goes around and collects blank proxies because they just don't know who to vote for, and he just says, I'll just fill them out. And
Right.
so other people can't get on the board. So even though you have a right to run, some of us can never get on because he fills them out and brings them to the meeting.
Right. Well, because that is related to elections, even though it's a homeowners association, you could contact the Division of Condominiums and see if they would assist with that issue. And if not, at least they have resources and information on it. So I think that would be a resource for you. Because they don't even allow proxies in condominiums because they know there's so much fraud. The only other option that you would have, and I can't tell you which one's better because I'm not allowed to give you advice, but would be to try to recall the president. But you would have to speak with the association members and get at least 50% of them to petition with you for recall.
It's small, you might be able to do
There's
it.
only like 60 units in my development, very tiny HOA, but
So if at least 50% of them either signed a written agreement, or you could create a ballot, voted for the recall of the president, then that will definitely get you into the condominium arbitration system, because if he doesn't accept the recall, the rest of the board doesn't accept the recall, then you have the right to the arbitration through the condominium association.
And then I had just one other question
Yes.
on right to inspect. The HOA statute is very, very, very vague. Right to inspect and copy most association records, but
Correct.
there's a lot of selective enforcement in my community, and some of us wanted to see violations, to see who, not necessarily who, but what violations are going out for certain things. All it is on it is the person's name and address. No social, no medical, no, you talked about one other thing that it cannot contain, but
Well, the list of documents in the statute doesn't say anything about violation reports. It just says minutes of the meeting. So if the violation was discussed at a board meeting and it was in the minutes, that's the only way that I would know that it's specifically protected by the statute.
Don't talk about violations of the meetings for that specific purpose.
Well,
Never brought up. Yeah, it's.
well, then that's definitely something that is not in the statute.
Is there any public site that you can find what violations may be going on or no?
Not that I'm aware of. But Florida does have very broad public records law, so you might want to look in general at the public records law, and there might be a way to make a public records request. I don't, the HOA, because it has its own statute, may be treated differently.
Yeah. Thank you.
But you can write that down and I can look into it. Anybody else?
Is it
Yes, sir.
possible to stipulate qualifications for directorship, because so many of the boards have very unqualified people. They
Well,
they
this-
don't know anything about construction, they don't know anything
Right.
about business, and it's like a...
The problem is that the law says that any member can run for the board unless they're a convicted felon or delinquent on their fees. So it's very broad. It would have to be per the governing documents. So the association as a whole would have to vote, and the majority would have to vote to make an amendment to the governing documents to add that to it. It's not in the statute.
So we could put it in the governing documents.
As long as you had a majority vote,
Oh, right.
you can require more. You just cannot require less. Anybody else? All right, well, thank you so much for coming. I did put some evaluations, if you can just take a second to fill them out, and then you could leave them on your way out, or leave them there on the desk and I'll pick them up. We're always looking for ways to make the workshops better or other topics, and thank you for coming.
When you have the next one like this, I'll come again.
Okay.